Hello there, I'm attorney Kelly Longtin from Kelly Longtin Law, where we provide effective estate planning for everyday families. And today I want to talk to you about why or the reasons that trust may terminate. So all good things come to an end. So we all know that nothing lasts forever. And while trust can stretch across generations and keep valuable money and property within a family, no trust has unlimited funds or an interminable time horizon. Every trust at some point is going to end, and the reasons why a trust might terminate can vary. But in general, termination occurs because the trust has accomplished its purpose and is no longer economically feasible and has distributed all of its property, is revoked, or is dissolved by the court because of a dispute or an illegality. So let's talk about what a trust is. Trust is a legal document in which one person, the trust maker, places the property in a trust and appoints someone, a trustee, to hold title to and manage trust property for the benefit of one or more people, the beneficiaries. The property placed in a trust can be money or real estate, securities, business interests, insurance policies, and other types of assets. And when a trust maker forms a trust, they can make it revocable, meaning they can modify or terminate it while they're still alive and competent. And a trust can also be irrevocable, meaning that the trust maker cannot modify or terminate the trust during their lifetime, except under a limited number of circumstances. Now, revocable trusts typically will become irrevocable when the trust maker dies. Now let's talk about when trusts terminate according to plan. Trust is set up with a specific purpose in mind, namely to distribute money and property to beneficiaries. Now, the most straightforward reason that a trust might end is that all of the money and the property in the trust has been distributed. At that point, the trust has outlived its usefulness and may be closed down. A trust can also end based on an age or a date termination. So the amount of time it takes to distribute all of a trust money and property can depend on its terms. Trust creators sometimes insert clauses that specify the age when a beneficiary is to receive the trust property. They might include language, for example, that property is to be transferred to a beneficiary only when they reach age 25. The terms could also be more nuanced, such as the beneficiary receiving 1/3 of the trust property at the age 25, then 1/3 at 30 or 1/3 at 35. And it can be set up however, the trust creator wants it to. The trust creator could also insert language stating that the trust automatically terminates on a specific date, and on that date, all of the assets are to be distributed. Trust can also terminate on triggering events. So instead of specifying a certain beneficiary age or a future date that triggers the trust termination, the creator might include a certain event or events that require the trust to end. The event could be a beneficiary's graduation from college, or a marriage or divorce, or the birth of a child. However, a triggering event that places unreasonable restraints on marriage or encourages divorce may be considered invalid and most likely will be. If the trust is revocable, the trust maker can decide to revoke it at any time and for any reason while they're still alive and competent. However, even irrevocable trusts can be revoked for some valid reasons. Sometimes unforeseen circumstances can force a trust to terminate. A trust typically wraps up after it's served its purpose of distributing money and property to beneficiaries according to its terms. But sometimes contingencies arise that force the termination or modification of the trust. And if that is the case, then the court may intervene on such occasions as this. Other times, a trust can be terminated by the trustee or the beneficiaries. The trustee can revoke the trust if the trust maker has expressly granted them the authority to do so. If a trustee wishes to terminate a trust but lacks the necessary authority, they can petition the court for a judicial termination. Trust beneficiaries, they may do the same. And the court may order the trust termination if the court is convinced that termination will not interfere with the trust's original purpose. Sometimes the trust will terminate because it's just no longer economically feasible. Administering a trust costs money, and usually about 1 to 3% of the trust's total value per year. The interested parties might agree that trust administrative costs outweigh the benefits to the trust beneficiaries. And the trustee and the beneficiaries could then petition the court to terminate the trust. Because a negative cost to benefit ratio can be a concern in some situations, the trust may even include a provision that allows it to be terminated if it's no longer economically feasible. Let's talk for a moment about trust contest. So as with wills, trust can be challenged or contested, and often a trust contest results from a dispute amongst the beneficiaries. There could be a dispute between the beneficiaries and the trustee, or somebody who believes that they should have been a beneficiary could contest the trust. Whatever the reason for a trust contest, such disputes usually end up in court. The court could order that the trust termination and the immediate distribution of its property to its beneficiaries. On the other hand, the court could place the property in a new trust, modify the trust terms, or appoint a new trustee. In other times, a trust is terminated for legal reasons, and a court may deem the trust illegal or invalid and may terminate it. Trusts cannot be created for illegal purposes, such as defrauding creditors, depriving a spouse of their rightful elective share, or operating an illegal business. Generally, a trust will be terminated if its purpose becomes unlawful or contrary to public policy. Note that some triggering events, such as unreasonably restraining a beneficiary's marriage, is definitely going to be considered prohibited as it's against public policy. And in addition, the trust maker must be legally competent to create a trust. A court can terminate a trust if it determines that the trust is created under duress, through fraud, or by mistake, or if the creator was not of sound mind when they created it. These arguments may be put forth as part of a trust contest. And the end of a trust signals the end of an era, even when a trust has simply outlived its usefulness and expires without controversy. A beneficiary or a trustee may have questions about how trust termination affects their rights and their responsibilities. When parties with an interest in a trust are not in agreement about its termination, the process can become even more complicated. At the very least, a record of the trust closure should be preserved. An estate planning attorney can help you with these and other trust-related issues. So if you have any issues about closing a trust, please feel free to call or contact our law office to speak with one of our experienced estate planning attorneys. So I hope you all found this beneficial. I am Kelly Longtin, founder of Kelly Longtin Law, where we provide effective estate planning for everyday families.